Good morning, Your Honors. The matter before the court is the case entitled George Woods Jr. versus Department of Corrections, case number 24 AP 351. Appellant George Woods Jr. is self-represented. Representing the appellee Department of Corrections is Robert Menzel.
All right, thanks very much, and good morning again, everybody. Mr. Woods, can you hear me, sir?
Yes, I can. Good morning, Your Honor.
All right, good morning to you, and thank you very much. We'll hear from you first, of course. You understand you have 5 minutes?
Yes, I do, sir.
Everything all right? Yeah, all right.
Yes.
Okay, you have 5 minutes, and we'll try to give you an alert before your time is up. So please go ahead.
Okay. My counsel bill to challenge de novo review under the violations in the NOS and the case staffing process. And then Tom Dunn had created conditions not having jurisdiction under 28 VSA subsection 352 and 353 as is the commissioner that's supposed to impose conditions. 2 conditions were made out of retaliation, and DOC allowed me to visit anyone else but Rebecca outside of Washington County. And this is in violation with the Rivers law under Rivers 2005 BT 65. I did not violate CJC rules. PNP made them evict me, and according to not making curfew, when I had been in contact with CJC officials prior to not making it for curfew, Tom Dunn, I had contacted him 2 days prior and contacted his supervisors along with all my supports. Then the document for the revocation contact was added the date of the hearing, of my NOS hearing, and not provided the 24-hour prior rules as that Jeff Lakeview had gave me a violation of conditions that did not have condition 12 on them. The Tom Dunn was made by somebody from the office to put condition 12 on the violation and then added another slip, another paper into the mix. So I'm going to reserve the rest of my time for rebuttal.
Okay, all right, that's fine. Thank you very much. We'll turn to appellee's counsel. Please, for the record, introduce yourself, identify your client, and then proceed.
Thank you, Your Honor. I'm Robert Menzel. I'm counsel for the Department of Corrections.
Thank you.
We are before the court today on a appeal from a review pursuant to 28 VSA 724 of a furlough violation. Mr. Woods is serving a sentence for a conviction of domestic assault, and he's been scored by the department as a high-risk offender. The victim of that crime was his ex-wife, Rebecca Woods. Mr. Woods was suspended from his furlough because he violated several conditions, most notably the condition that restricted contact with his ex-wife, who was the victim of his index offense. The violation based on the contact with his ex-wife was supported by the agency record and his own testimony. Condition C12 specifically stated that appellant was prohibited from entering or inhabiting a residence that his supervising officer denied based on a risk to the public or to his victim. He also had a condition that contact with his ex-wife was restricted to Washington County from January 4th, 2024 until February 2nd, 2024. The violation was also supported by appellant's own testimony, during which he admitted that he decided to stay at his ex-wife's residence in Lamoille County in violation of those conditions. He also admitted on cross-examination that he knew he wasn't supposed to stay at his ex-wife's residence overnight, as well as claiming that he didn't need permission to do so. So the trial court's findings regarding that violation were supported by the evidence presented and were not clearly erroneous. 724, the 28 VSA 724, the Superior Court's review is limited to determine whether the decision to interrupt or revoke an offender's community supervision furlough status was an abuse of discretion by the department. And an abuse of discretion is presumed unless the offender's risk to reoffend can no longer be adequately controlled in the community, or the violation or patterns of violations indicate the offender poses a danger to others. And the court, upon hearing the evidence, made findings that those particular exemptions applied, and that the department's decision was not an abuse of discretion because the violation or the pattern of violation indicated that the offender posed a danger to others, specifically Ms. Woods. She was the victim of his index crime. She was also the subject of some previous violations of furlough that had occurred, and there was a concern that that his utter disregard for the conditions of supervision put her in danger, and that he posed a risk of danger to the community. The court also found that that it was a pattern of events and that there were no other means available to the department to be able to supervise him safely in the community. He had sort of a tumultuous supervision history, but he wasn't revoked initially. He relapsed during his supervision and had contact with his ex-wife in violation of those conditions. The department didn't revoke him straight up. They brought him back in. They went over some other conditions with him. They reaffirmed that he wasn't supposed to have unauthorized contact with Ms. Woods. And despite those,
You have 1 minute. You have 1 minute, sir.
Thank you, Your Honor. Despite the opportunity to sort of get back on track with his supervision, Mr. Woods continued to violate the conditions of his supervision, and by violating the house rules at the Community Justice Center residential placement that he had, by violating his curfew, which he admitted to that during his testimony at trial. And most concernedly, obviously, the continued unauthorized contact with his ex-wife, who was the victim of his index crime. So the department respectfully requests that the court affirm the lower court's decision. There was no abuse of discretion here, and the lower court's conclusions of law were supported by the facts in the record and the testimony that was adduced at trial.
Thank you.
Therefore, the case should be affirmed.
Thank you. Your time has expired. How much time does the appellant have, please?
Appellant has 3 minutes, 15 seconds remaining.
All right,
Yes,
Mr. Woods, did you hear that? Yeah.
Yes.
Okay, go ahead, sir.
Okay, Your Honor. My dispute is that the alleged victim was not the victim at the time. We are definitely engaged in relations without no type of violence whatsoever. She had filed a 28 VSA subsection 252.14 with my PO to prevent my PO from any non-restrictive contact. She wanted full contact. I'm on the lease of my apartment. My problems of the domestic occurred 10 years ago. I had done treatment and also programming to be able to have contact with my spouse. The Vermont Department of Corrections had created in 2020 false allegations that imposed Mr. Dunn to create conditions, and I have the documentation to show that the false allegations, there's something going on with this hearing.
I'm sorry.
Hello. Yeah, I knew it.
Are you still
They
there?
shut me off.
No, I can still hear you.
Well, I'm going to continue talking, but you guys, my motion to the appeal speaks for itself in regards to all the documentation. There's a case stat form, exhibit A, B, and C that show the documentation being altered and information from Lynn Bushy telling the central office that I was being charged criminally, and I was not. I was never given a hearing of whatsoever for that conduct. It's hard to speak when this thing just keeps on rolling. Someone shut me off deliberately. I knew this was going to happen.
Well,
I can predict
your
every single damn
your
hearing that I
video
have
is
on this
off.
damn audio because DOC literally alters everything.
Okay. Your video is up, but we can hear you, Mr. Woods.
Once I start talking about damn this is
You
fucking.
still, Mr. Woods, can you hear me?
Can you get my
Mr. Woods?
caseworker? I'm in the middle of a hearing and it just went off.
How much time, Mr. Bailiff? How much time is left for the appellant?
I stopped the clock at 1 minute, 6 seconds when we had issues.
All right. Well, let's call
This
it.
is what went on.
Mr. Woods, can you hear me?
Oh, I turned it off? Austin,
Mr.
in the middle of the
Woods?
hearing.
Can someone call the facility and see if we can get him back on the line, on the telephone, even if there's no video?
But we've been having that shortage of internet all day today. Probably got it wrong. But and he's not there. Oh, yeah.
Mr. Woods? Mr. Woods? Did you get through to anybody, Petra?
I asked Jerry to call them.
Okay. Let's see if
but-
we can get him back on the line so we could finish the hearing. I'd like to do that.
Okay.
You guys shut this off deliberately.
Yep. Can you hear me, Mr. Woods? Hello? Can you hear me?
Oh, I can't type.
Hello? Can you hear me? Hello? 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 Can you hear us? Hello? Can you hear us?
Yes, I can. No, I cannot.
Oh, you can hear. Can you
It's
hear
all
us,
messed
Mr.
up.
Woods? Mr.
I don't
Woods,
know if you can hear me.
we can hear you.
Yeah, well, all this thing is
Go
doing
ahead.
is rolling, and it's hard to talk to a rolling computer.
You
I was just in the middle of my argument and just went haywire because I
Miss-
started talking about DOC's corrupt nature providing the conditions for Christ's sakes.
Mr.
Happens every
Woods,
single time I have a hearing on WebEx.
Chief,
Every
Mr.
single
Woods,
time.
Yeah,
Do you want me to tell him how much time he has left in text and then just ask him to finish
Yeah.
his argument?
yeah,
Okay.
that sounds like a good idea.
Alex, how much time does he have?
1 minute, Mr. Bailiff, 1 minute, 6 seconds. Yeah,
Okay, 1 minute, 6 seconds. All I gotta say is that my appeal pretty much speaks for itself. Uh, that I've written, there's documentation that has been altered. Jeff Leggio is the original person that served me with the NOS hearing. Tom Dunn had revamped it, put the condition 12 on the violation. I was not originally charged with that violation. I do not meet the criteria, under 2724 D1, 2, 3, to keep me incarcerated past 90 days. As there's dicta under Mitchell versus Department of Correction, 2021, VT Super Lexus 56, as this guy had absconded and he received 90 days. I did not abscond. I let everybody know about all the problems, and therefore I don't belong incarcerated, nor did I belong incarcerated, as I worked with all my people.
all
Yeah,
right.
I
Thank you
wasn't
very
very.
much. Your time has expired, sir.
Uh,
Your time has expired. Please call the
I
conclusion of the
want to hear the
hearing.
person here.
The next hearing for the court will follow immediately.
I'm going to
Thank you
submit
both.
my brief to the
Yeah.
court. Considering the circumstances that had happened, I hope to hear back from the court within 14 days, and or by counsel within 7. DOC has continued to. Yeah, here we go. Yeah, that's awesome.